Good day. I'm Vannessa Nicholas, the Head of Estates Administration at Appleton Fiduciary Services. Today, I want to talk to you about the administration of a deceased estate. A deceased estate comes into existence when a person dies. The estate of the deceased is administered in terms of the will. Alternatively, should they not have a valid will, in terms of the laws of intestate succession. The procedure which we follow is set out in terms of the Administration of Estates Act. The process that we follow goes through a number of stages in order to bring the estate to finality. We'll look at each of these stages. First of all, the notification of death, estate interview. What this entails is meeting up with a family member and gathering all of the information that is required in regard to the assets and liabilities of that particular deceased person. The estate administration process consists of a number of steps which we follow in order to bring the estate to finality. Notification of death, estate interview. This particular aspect of the estate is when we meet with the family and obtain the necessary information in regard to the assets, the liabilities, and details of pension funds, medical aid, and any other documentation that we require in order to administer the estate. We also need to complete certain documentation with the family in order to report the estate. The estate needs to be reported to the Master of the High Court within 14 days of someone passing. Once we have all the necessary information from the family, we can then proceed to make application to the Master of the High Court in order to be appointed as the executor. The documentation is submitted to the Master of the High Court. Should the Master of the High Court be happy with the information submitted, he will then appoint us in terms of the will, alternatively in terms of intestate succession, should the deceased not have a valid will. Once the letters of executorship have been appointed, the Master of the High Court will issue letters of executorship in terms of which he appoints the executor, Appleton. We have then a duty to place a Section 29 advertisement in the local newspaper calling on debtors and creditors to come forward with any claims they may have against the estate. They have a period of 30 days in which to come forward with these claims. Once this period has expired, we then proceed to prepare a liquidation and distribution account. The liquidation and distribution account sets out all the assets and liabilities in the estate and how the estate is distributed in terms of the will. The liquidation and distribution account also sets out the income and expenditure of the deceased and of the estate after date of death. This would be interest on estate funds as well as income in respect of shares or rental income, dividends from shares or rental income. The liquidation and distribution account can only be prepared once all assets and liabilities have been ascertained. All assets need to be valued as at date of death, alternatively sold. The liquidation and distribution account is then submitted to the Master of the High Court for his approval. Should the Master approve the account, he will issue us with what we call the Master will issue us with a query sheet. The query sheet will confirm that we may proceed to advertise the account. Alternatively, the Master will raise any queries he may have against the account. Once we have the approval from the Master of the High Court that we can proceed with the advertising of the liquidation and distribution account, we are to place an advert in the local newspaper as well as the Government Gazette, confirming that the account will be lying open for inspection for the statutory period of 21 days. The liquidation and distribution account also is sent to the local magistrate in the area in which the deceased resided. Once the account has laid open for inspection and there has been no objections lodged by any of the public, we then can proceed to attend to the distribution of the estate. Distribution of the estate. What is the distribution of the estate? The distribution of the estate is the distributing of the assets. So if there is a property in the estate, we will then proceed to transfer the property into the name of the heir. If there are shares to be transferred, we will proceed to transfer those shares to the heir. In the same instance, we will pay any debtors which need to be paid, as well as distribute cash inheritance to the heirs in the estate. We also need to make sure that we have liaised with the receiver of revenue in order to make sure that we have submitted all the necessary tax returns that need to be submitted. And then finalization and closure of the estate occurs once we receive a deceased estate's compliance letter from the receiver of revenue and once we receive a filing slip from the Master of the High Court. The Master of the High Court will only issue us with a filing slip once we have provided the Master with confirmation that all assets have been distributed to their rightful heirs, as well as confirmation that we are no longer holding any estate funds which belong to the estate. Upon receipt of the filing slip, the deceased estate's clearance certificate, we can then close our estate and finalize the estate and archive the file. So in a nutshell, that is the administration of deceased estates, going through the various stages in order to bring the estate to finality.